डॉक्टर बाबासाहेब आंबेडकर ओपन युनिव्हर्सिटी.
Good evening, friends. Friends, I am Dr. Dhaval Pandya. Welcomes you all from the Chaitanya Studio of Dr. Babasaheb Ambedkar Open University. Today we are going to learn about business law. This is a lecture in continuation of previous lecture. Business law comes in semester 1, and the code of this subject is MBA01C106. Unit number 1, Indian Contract Act 1872-I. First we'll see what we learn, and then accordingly we will move further. In previous lecture we learned about introduction to law, what is law, need for a knowledge of law, introduction to Contract Act, source of mercantile law, object of the law of contract, features of the law of contracts. Today we are going to learn about essential elements of a valid contract, classification of contract, offer and acceptance, and consideration. It's a large one, quite big unit. So these three topics we are going to cover, we are going to learn. So starting from first, essential elements of valid contract. According to section 10 of a Contract Act, all agreements are contract if they are made by the free consent of parties competent to contract for a lawful consideration with a lawful object and are not expressly declared to be void. In order to become a contract, an agreement must have the few essential elements. First, offer and acceptance, minimum of two parties. There must be a minimum of two parties of an agreement, that is, one party making the offer and the other accepting it. The term of an offer must be definite and the acceptance of the offer must be absolute and unconditional. The acceptance must also be according to the mode of prescribed and must be communicated to the offerer. Second, intention to create legal relationship. When two parties enter into an agreement, their intention must be create a legal relationship between them. If there is no such intention or the parties, there is no contract between them. Agreements of social or domestic nature do not contemplate legal relationship, and as such they are not contract. Third, lawful consideration. An agreement to be enforceable by law must be supported by consideration. Consideration means an advantage or benefits moving from one party to another. It is the essence of a bargain. In simple word, it means something in return. The agreement is legally enforceable only when both the parties give something and get something in return. Fourth one, capacity of parties, competency. The parties to the agreement must be capable to entering into a valid contract. Every person is competent to contract if he or she A is of the age of majority, B is of soul mind, and C is not disqualified from contracting by any law of which he is subject. Flow in capacity to contract may arise from minority, luxury, idiocy, drunkenness, and status. If a party suffer from any flow incapacity, the agreement is not enforceable except in some special cases. Fifth, free and genuine consult. It is essential to the creation of every contract that there must be a free and genuine consent of the parties to the agreement. The consent of the parties is said to be free when they are of the same mind on all the material terms of the contract. Lawful subject. The object of the agreement must be lawful. In other words, it means that the object must not be illegal, be immoral, or C opposed to public policy. If an agreement suffers from any legal flaw, it would not be enforceable by law. 6. Agreement not declared void. The agreement must not have been expressly declared void by any law in force in the country. 7. Certainly and possibility of performance. The agreement must be certain and not void or identified. If it is void and it is not possible to ascertain, it means it cannot be enforced. 8. Legal formalities. A contract may be made by words spoken or written. As regards to legal effects, there is no difference between contract in writing and a contract made by word of mouth. It is, however, in the interest of the parties that the contract should be writing. Now, classification of contracts. Now we will see the classification of contract. Classification of contract. Basics of classification: validity, formation, and performance. In validity, valid contract, void contract, voidable contract, illegal contract, and unforceable contract. Formation, information, express contracts, implied contract, quasi contract, and in performance, executed contract and extraordinary contract. Executory contract. Okay. First, classification according to validity. First, classification according to validity. According to valid contract may be valid contract, void contract, voidable contract, illegal contract, unforceable contract. 5. Valid contract according to section 10. All agreements or agreements are contract if they are made by the free consent of parties competent to contract for a lawful consideration and with a lawful object, and are not hereby expressly declared to be void. Thus, only a valid contract can create legal obligation. Second, void contract. According to section 2 of C, a consent which causes to be enforceable by law becomes void when in it cases to be enforceable. An agreement which was legal and enforceable when it was entered into maybe subsequently become void due to say impossibility of performance and change of law. Third one, voidable contract. According to section 2I, an agreement which is enforceable by law at the portion of one or more parties thereto, but not at a option of other or the others, is a voidable contract. Fourth, illegal contract. An illegal agreement is one which is against law in force in India. Such a contract is one which is criminal in nature or which is immoral or which is against public policy. Fifth, unforceable contract. An unforceable contract which through perfectly valid in all respect lacks some technical requirements needed to make it enforceable, such as non-registration, want of proper stamp, lack of signature, etc. Such contract can be enforceable in future if if these defects are caused. Now, classification according to performance. According to formation, contract can be express contract, implied contract, quasi contract. Now, first, express contract. What is express contract? When the offer enumerates express terms, such a contract is called express contract. According to section 9, a contract is said to be express when it is entered into by word spoken or written. Second, implied contract. An implied contract is one which is not expressly upon between the parties but is inferred from the act of conduct of parties or course of dealing between them or from the surrounding circumstances, like takes a public bus or a particular route. Thus, an implied promises result in an implied contract. Now, third, quasi contract. A quasi contract is created by law. Quasi contract does not fulfill all the requirements for the formation of a contract, and in the strict sense is not a contract at all. These are certain obligations which are not in truth contractual in the sense of registering agreement or agreements, but which the law treats as if they were. Now, classification according to performance. Contract according to performance may be executed contract, executory contract, executed contract. Now, executed contract. An executed contract is one where both the parties have performed their obligations under contract. First. Now, executory contract. An executory contract is one where both the parties have yet to perform their obligation, like agrees to deliver a car to B. A agrees to deliver car to B at rupees 5,000, and if A has not delivered the car nor B has paid, the contract is said to be executory contract. Now comes offer and acceptance. It's a long. First we'll start with offer. Offer and acceptance. We'll start with offer. At the inception of every agreement, there must be a definite offer by one person to another, and it is unqualified acceptance by the person to whom the offer is made. An offer is a proposal by one party to another to enter into a legally binding agreement with him. A person is said to have made a proposal when he signifies to another his willingness to do or to abstain from doing anything, with a view to obtaining the assent of that other to such act, or abstains. Section 2A. Rule of a legal offer. Rules of a legal offer. First, offer must be such as in law is acceptable to being accepted and given rise to legal relationship. A social invitation, even if it is accepted, does not create legal relations because it is not so intended. An offer, therefore, must be such as would result in a valid contract when it is accepted. Second, terms of offer must be definite, unambiguous, and certain, and not loose and void. If the term of an offer are void or indefinite, its acceptance cannot create any contractual relationship. But if the agreement contains a machinery for asserting a void term, the agreement is not void or the ground of its being void. Third, an offer may be distinguished from A. 1. A declaration of intention and an announcement. A declaration by person that he intend to do something gives no right of action to another. Such a declaration only means that an offer will be made or invited in future, and not that an offer is made now. Second, an invitation to make an offer or do business. Despite of goods, they are shopkeepers in his window with price marked on them, is not an offer but merely an invitation to the public to make an offer to buy the goods at the marked price. Fourth, offer must be communicated. An offer to be complete must be communicated to the person to whom it is made. Unless an offer is communicated to the offeree by the offerer or by his duly authorized agent, there can be no acceptance of it. An acceptance of an offer is ignorance of the offerer, is no acceptance, and does not confer any bind on the acceptor. Fifth, offer must be made with a view of obtaining the assent. The offer to do or not to do something must be made with a view to obtaining the assent must the other party address and not merely with a view to disclosing the intention to making an offer. Sixth, offer should not contain a term the non-completions of which may be assumed to another to acceptance. Thus, a man cannot say them if acceptance is not communicated by the certain time. The offer would be considered as accepted. Seventh, a statement of price is not an offer. A mere statement of price is not constructed as an offer to sell. Eighth, special terms in a contract. Where any special terms are to be included in a contract, these must be duly brought to the notice of the offeree at the time when the proposal is made. If it is not done and if the contract is subsequently entered into, the offeree will not be bound by them. Also, these terms should be presented in such a manner that a reasonable man can become aware of them before he enters into a contract. Now, acceptance. A contract emerges from the acceptance of an offer. Acceptance is the act of assenting by the offeree to an offer. In other words, we can say it is the manifestation by the offeree of his willingness to be bound by the term of the offer. It is to an offer what a legality lighten much is to a train to gunpowder. It produces something which cannot be recalled or undone. This means when the offeree signifies his assent to the offerer, the offer is said to be accepted. An offer, when accepted, become a promised. Section 2b. Rules of legal acceptance. First, it must be absolute and unqualified, like it must conform to the offer. An acceptance, in order to be binding, must be absolute and unqualified. Section 7a. In respect of all terms of the offer, whether material or immaterial, major or minor, if the parties are not idle on all matters concerning the offer and acceptance, there is no contract. Second, it must be communicated to offerer to conclude the contract between the parties. The acceptance must be communicated in some parties from a mere resolve or mental determination on the parties of the offeree to accept the offer. When there is no external manifestation of the intention to do so, is not sufficient. In order to result in a contract, the acceptance must be a matter of fact. Third, it must be according to the mode prescribed or unusual and reasonable mode. If the acceptance is not according to the mode prescribed or some unusual and reasonable mode, where no mode is prescribed, the offerer may intimate or the offeree within a reasonable time that the acceptance is not according to the mode prescribed and may assist that the offer must be accepted in the prescribed mode only. If he does not inform the offeree, he is deemed to have accepted the acceptance, section 7a. Now fourth, it must be given within a reasonable time. If any time limit is specified, the acceptance must be given within that time. If no time limit is specified, it must be given within a reasonable time. Fifth, if contract precede an offer, there can be no acceptance of an uncommunicated offer. Acceptance cannot precede an offer. A person who has no knowledge of an offer cannot be said to have accepted it merely because he happened to act just by chance in the manner prescribed by the offer. Sixth, it must show an intention to the parties of the acceptor to fulfill terms of the promise. If no such intention is present, the acceptance is not valid. Acceptance is ordered to be valid must be made under circumstances which would show that the acceptor is able to willing to fulfill the promise. Acceptance must show an intention on the part of the acceptor to fulfill the promise. If no such intention is present, the acceptance is not valid. Now 7. It must be given by the party or parties to whom the offer is made. If the proposal is made through an agent, it is sufficient if the acceptance is communicated to him. Now 8. It must be given before the offer lapses or before the offer is withdrawn. The acceptance to an offer must be given before the offer was withdrawn. When an offerer has made an offer, he holds the right to withdraw the offer at any time prior to the acceptance. As we were discussed earlier, once the acceptance is done, the offer turns into a contract, but the offerer can withdraw the offer before the acceptance. Hence, it is important for the offeree to give the acceptance before the lapse of time of the offer in case where an offer is time bound, then and only then, or the offer is withdrawn. 9th, it cannot implied from silence. The acceptance of an offer cannot be implied from the silence of the offeree or his failure to answer, unless the offeree has been his previous conduct indicated that his silence means that he accepts. Okay, now consideration. Consideration is one of the essential and most important factor of valid contract. It is made compulsory to have consideration to formulate a valid contract. In the law, it is used in the sense of quid pro quo, like something in return. Essential elements of consideration: first, it must be moved as the desire to the promiser, means to be a valid consideration, it must move at the desire or request or intention of the promiser himself and none else. If it moved at the desire not of promises, even though the promise is benefit from consideration, the reciprocal promise made by him shall not be enforceable in law. Such consideration is invalid. Second, it may move from promise for any other person. In English law, consideration while moving at the desire of the promiser must move from promise only and none else. Indian law differs in the respect and provides that consideration may move either from the promisee or any other person. According to the law, in the background of Indian circumstances, so long as consideration is present and moved at the desire of the promiser, it is immaterial who has finished it. So, consideration, if present, may move from third party also. Third, uncertain form. The form of the consideration provides in a contract is not fixed or certain. As indicated by section 2D, it may be formed into either an act, doing something, or abstinence, reframing from doing something, or a promise to do or not to do. Any type of consideration is considered as valid by the law, and unless it in contract, a party cannot insist for a particular from a consideration. Fourth, it may be past, present, or future. The word of section 2D are has done or abstain from doing past, or does or abstain from doing present, or promises to do or the abstain from doing in future. This clearly means that consideration may not necessarily be present. When a consideration is moved from something which has been done earlier, or when a consideration is moved from a promise to be fulfillment later on, all these are valid consideration. Fifth, if need not be adequate, it need not be adequate. It also provided by the law that something must be given and obtained by the parties in a contract. This something, however, need not necessarily be adequate or equal to something given. Sixth, it must not be illusory. If a person is already bound to do some act or abstains under his legal or contractual obligation, the act or abstains would not form a consideration for a fresh promise. That means, as it is the duty of the person to fulfill the obligation, he cannot expect another promise from the other party to satisfy his legal or contractual obligation. Now, 7. It must be lawful. To be enforceable consideration must be lawful. Lawful consideration. If it is unlawful, there shall not be any enforcement. Consideration is unlawful. It is either illegal or immoral, or oppose the public policy, or is of such a nature to contravene one or more provision of any law in the country, or if permitted It evolves a moral termite. In such cases, the consideration as well the contract will not be enforceable. Exception to the rule: no consideration, no contract, or no consideration, no contract. Consideration, the most important elements of the valid contract, must always be present into a contract to the enforceable. If the consideration is not present into a contract, according to the section 25 of the act, the contract become a void agreement, like it is void ab initio, and no right shall be conferred over either the party under the contract. These exceptions are like natural love and affection. According to section 25 in the contract is entered into in a written form and is registered under the law of registration of the country between the parties who stand into near relations within each other, and account of natural love and affection between them, such a contract shall be enforceable even though it is without consideration. The section gives a list of relations only when are permitted for these exceptions in list, as father son, father daughter, mother son, mother daughter. Even though the list is permitted to be taken up by there must be a proof of natural love and affection between the parties. Second, promise to compensate the voluntary services. Voluntary, a promise of contemporary, wholly or in part, another person of any services, act done or abstain carried by him in past voluntarily shall be enforceable even though the promise is not reciprocated by consideration. However, to enforce such promise, few consideration must be satisfied. First, the act or the services or the abstinence must have been made up by voluntarily by the promise. The promisor now promises to compensate the promise. The act done must have been a legal obligation of the promisor. The promisor must be in existence when the act was carried on. The act must have been a lawful one. So these are things. Now third, promise to pay a time bad debt. A promise to pay a time bad debt can enforceable by the creator when though no fresh consideration is provided by him for such a promise. According to Indian law of limitation, a debt become a limit bad debt when it remains unpaid or uncertain, wholly or part, for successive period of 3 years. On the expiry of third year, such debt becomes legally irrevocably, and the correct between the parties become to an end, and creditor shall not have any remedy. The enforce such a promise, however, the few consideration must be satisfied. For the debt must have been actually a time bad debt. A debt must provide the promise after expiry of period of information. The debt must be a lawful one. These are the things. Now fourth, completed gifts. The concept of no consideration, no contract does not apply to completed gift. Completed gift means the gift which have already been executed by given to somebody. In such a case, the person provided the gift cannot recover it from the promises on the ground of want of consideration. However, this exception is not applicable to the gift which is yet to be executed. Thus, a promise to gift cannot enforceable. And 5. Last, agency. Creation of agency does not require presence of consideration from either side. According to section 185, the relation between principal and agent is such as such in which the principal is bound by act done by the agent, but agent is not bound in that way. So principal provides the consideration, the agent does not. Thus, certain of agency is an exception. So now here are few questions from this unit. Essential elements of a void contract discuss in detail. Second question, what is classification of contract? Describe in detail. What is the law of contract? Described its feature in detail. What is acceptance? What is rule of legal acceptance? And finally, what is consideration? Describe in detail. So friends, here we complete our lecture. In next lecture, we will continue with this lecture series with this unit only. Till then, goodbye and take care. Namaskar.
स्वाध्यायः